My name is Evan Conroy. I'm an attorney at Conroy Law. This video is an introduction to leasing restrictions for Indiana community associations. First, let's go over what leasing restrictions are. Leasing restrictions are written restrictions contained in a community's governing documents that restrict or prohibit certain types of activities related to leasing property. They can affect long-term leases, short-term leases, or both. Long-term leases typically involve leases that last for 12 months or longer, whereas short-term leases, sometimes called transient leases, are shorter. These sorts of leases can last sometime between a few months, a few days, or even just a single night. For example, leasing through websites such as Airbnb and Vrbo would typically be considered short-term or transient leasing. Let's go over some of the reasons to restrict leasing. One reason is related to financing for home purchasers. You may have heard of Fannie Mae and Freddie Mac. These are government-sponsored enterprises that buy mortgages from lenders. Properties that are eligible to be financed by Fannie Mae and Freddie Mac-backed mortgages offer access to lower-cost financing. However, these enterprises have requirements that can change from year to year and have restrictions related to rentals within certain types of communities, such as condominiums. Another reason to have leasing restrictions is the perception that tenants do not maintain their leased property. The argument is that because tenants do not own the property, they are less likely to invest the time, money, and energy to make the necessary maintenance and repair work for the property to keep the property at the same condition as the community-wide standard. Another perceived issue is the concern that tenants will not be willing or will not know to abide by the community's covenants and restrictions. An additional possible concern for communities is not knowing who is living or staying overnight in your community. This could be particularly concerning for properties being leased out to transient tenants from websites like Airbnb and Vrbo. That being said, there are some reasons to avoid or reduce the severity of leasing restrictions. For example, for some communities, particularly condominiums and townhome-style developments, properties that are subject to strict leasing restrictions may be less marketable. Some owners may be worried about giving up property rights, such as the ability to lease their own property. Another concern some owners may have is that they may one day, due to a hardship, feel that they would need to lease their property, such as due to having to relocate for work, or leasing out a room if they lose a job or have reduced hours. Let's now discuss the basic legal theory on how leasing restrictions actually work. Leasing restrictions are a type of restrictive covenant. A restrictive covenant is an agreement between parties where one party agrees to not use their property in a particular way. These sorts of written agreements run with the land, which means that the restriction transfers when there's a change in ownership, restricting both the current and the future owners. These sorts of restrictive covenants, restricting land use from certain types of leasing activity, are going to be made part of the association's other restrictive covenants. The association's restrictive covenants are found in its recorded declaration of covenants. In a moment, we'll go over how leasing restrictions are added to the declaration of covenants. Before doing so, let's go over local, state, and federal law and how they can affect leasing restrictions. First, let's discuss federal law. The set of laws that seem to most impact leasing restrictions are those found in the Fair Housing Act. The Fair Housing Act is federal law that prohibits discrimination in renting, buying, financing, or advertising housing based on race, color, national origin, religion, sex, familial status, or disability. In Indiana, there was a 2008 Supreme Court of Indiana decision that overruled a trial court's ruling that a HOA's leasing restrictions violated the FHA. That being said, community associations still need to be very careful not to accidentally include language that would be seen as discriminatory under the Fair Housing Act. Besides federal law, both local ordinances and state laws can affect leasing activity. For example, both the City of Fishers and Carmel in Hamilton County implemented leasing caps for long-term rentals. Those ordinances were effective regardless of what leasing activity was otherwise permitted within the community association's governing documents located within those cities. The ability of leasing caps to be implemented at the local level, however, changed on July 1st, 2026. At that point, changes in Indiana law took effect. The new law prohibits local governments from adopting or enforcing new rules that prohibit or restrict owners of residential properties from renting property. Those cities that already had ordinances in place, such as Fishers and Carmel, can remain in effect until January 1st, 2028. The changes in the state law will not prohibit HOAs or condos from having their own restrictions on leasing. There are additional state laws concerning short-term rentals. This set of laws expressly provides that it does not apply to HOAs and condos own otherwise valid short-term leasing restrictions. Let's now go over how to go about adding leasing restrictions to a community's governing documents. The community association is going to need to amend its declaration of covenants, the document that is recorded in the land records. The declaration itself will have language within it explaining how to amend it. For example, the declaration should have language explaining the percentage of owners that need to consent to the amendment. When looking at the percentage requirements, if your community is an HOA, you're going to want to make sure the percentages have not changed due to the 2026 changes in state law. And be mindful that the 2026 changes in law treat current investor owners differently from those owners that list their property as a homestead when it comes to seeking to approve these sorts of amendments. An association will also need to ensure it complies with any other requirements contained within the declaration, as well as state law concerning nonprofits and their specific HOA type, such as applicable notice requirements and how owners evidence their consent of the amendment. Put another way, how are they going to become aware, that is the owners, of the proposed amendment, and how are the owners going to vote on it? For example, will it be voted on at a specially called meeting of the membership? Finally, let's go over some strategies for getting a leasing amendment approved. To help educate the membership of the need for the leasing requirement, the association could hold an information town hall meeting. Another possible clause that might be helpful to convince owners to vote to approve the leasing restrictions is an undue hardship clause. Such a clause would allow an owner to request an exception, allowing them to lease their property if they can show to the board that they have a hardship, such as an unexpected job relocation. Another possible option is to restrict but not ban leasing by having a leasing cap. Essentially, a cap allows for only a percentage of properties to be leased within the community. Thank you for watching this video on leasing restrictions for community associations in Indiana. If you'd like to learn more about other community association topics, please check out our other educational videos. Thanks again. I hope you have a great day.